Welcome to Mark My Words with Cole Carlson.
Hello, everyone, and welcome to Mark My Words with Cole Carlson, where entrepreneurs, inventors, and business owners can learn how to protect the ideas, brands, and innovations they're building. Cole's the managing attorney at Carlson IP Law in Tampa, Florida. I'm Sean O'Connor, and today we're going to talk about how to protect a new business idea. But first, Cole, good to see you.
You as well.
Love this topic, and really interested. I know we're going to start at the ground floor and over the course of episodes sort of work our way through IP and startups and all that stuff. But let's kick it off with just understanding a little bit about you, your background. How'd you get into intellectual property law?
Yeah, absolutely. So I started off at Vanderbilt University. I studied chemical engineering. Big fan of chemistry. And it wasn't until I got to college that I realized I wasn't going to be a great engineer. So I had to do something about that. And I thought, what's the best way to do that? But go to law school. So I was drawn to IP by my mentors and by watching some businesses grow without having a protection plan in place. And sometimes they realize that a little bit too late. And so my idea behind my firm and my practice is making sure that those innovators understand what they need to do before someone else can take advantage of them, and so that I can maybe help them become the next Tesla.
Yeah. Well, it's interesting because, it's related. You start off in chemistry thinking, that'll be my calling. I got to imagine that, that comes into play occasionally, just in terms of a general understanding of, because chemistry and inventions and all that are intertwined, and depending on the industry.
Absolutely.
You mentioned, sort of witnessing mistakes, so to speak, that colleagues or peers had made. How early in the process should founders start thinking about, protecting the idea, the new idea?
Sure. So that's a day one thought process. You don't want to wait until the business takes off.
Right.
For example, if you have a brand new product that you're trying to bring to market, any sort of public disclosure may foreclose any sort of patent protection, potential loss of international rights. And then domestically in the United States, there's a 1-year disclosure deadline. So you can launch your business, launch your product 5 years down the road, realize somebody else is ripping you off with the same product, and be left out in the rain.
Got it. Well, I think about like how soon should founders, and like almost the language of how soon should you be thinking of yourself as a founder, which is a certain, you know what I mean? Like it's just some dude with an idea versus, no, I'm a founder and I need to kind of button this stuff down early.
Absolutely.
That's interesting mindset too. How do I know, if I've got an idea, how do I know if it's something that can actually be protected legally?
Sure. So there's basically 4 categories of intellectual property that business owners starting out need to really worry about.
Okay.
Pure concepts on their own are not generally protectable. So you have an idea for something like, an application for dog walking. Okay.
Yeah.
That on its own, not protectable. The technology behind how that app might work is potentially patentable.
Okay.
That's something you need to think about. The name or the logo you come up with for the business, that is potentially trademarkable. The code or the content behind that application could be protected by copyright, which that does automatically come into existence as soon as you generate it, but registering it provides stronger standing from a litigation standpoint should someone decide to infringe. And then the final category is trade secrets. And a lot of people fall into this trap where, they have some sort of secret sauce to their business that they realize is the secret sauce way after the fact. And they've told many, many people about, the general ideas of it. And if it's enough to cobble it together, for a third party to cobble it together, then you no longer have that protection over that secret. Mm-hmm. And so it's important to think about everything from the outset, all 4 categories, and think about what you have. And most entrepreneurs, their ideas have multiple layers to it. And so it's important to map that out from the start.
It's interesting. A couple things come to mind there. It's that, okay, I discover sort of a year in or whatever that, oh yeah, the secret sauce is X, Y, Z. And I've kind of, how does it even uh, come to light that you've told too many people? You know what I mean? Like,
Sure.
you're my attorney. I come to you. I'm like, Cole, I realize that, hey, this thing over here is actually our secret sauce. Are you going to like, have you told anybody about it? Or is it, speak to that?
Yeah, absolutely. So that'll be my number one question. Who have you told? Is it family? Probably not a problem.
No big
Is
deal.
it close friends? Probably not a problem. Telling your employees, could theoretically become a problem if they were to ever leave the company. Obviously, talking with competitors about that information, definitely a problem.
Yeah.
So it's a layering of the different people that you're talking to as
I
to
see. Yeah,
when
so
it
there's
becomes
specifics.
important.
Interesting too. You mentioned code being copyrightable, right? Was that
Mhm.
not true? Yeah. I mean, as I'm a writer, I understand like, okay, it's, there's a certain implicit copyright, but I wasn't thinking about computer code that one might write.
Absolutely, yeah. Computer code is a work of the literary arts just as much as Moby Dick.
Yeah. Interesting. And then how do you go about, figuring out whether you need, a patent, a trademark, copyright, or some other kind of protection?
Absolutely. So I'll go through each one independently.
Okay.
With patents, you're looking at a process or a manufacturer or a system that's new, functional, and non-obvious. Okay, and what that means is when you're looking at everything that's come before, one, does it have all of the elements of what you're trying to protect? My favorite example is a chair. So a chair with a seat, a back, and four legs. If there's somebody else out there has sold a chair with a seat, back, and four legs before you try and get something registered, you're out of luck. And then in the obvious regime, if somebody out there had a stool with a seat and four legs, and let's say a rocking chair with a seat and a back, well, people who understand chairs would understand that you can put those two things together to make a chair with a seat, a back, and four legs.
Mm-hmm.
And so that's the type of analysis that needs to be done on the front end with a patent to determine whether or not you have something that can be patentable. And it's really looking at all those elements and what came before. With trademarks, that's your brand identity. That's your name, your logo, a slogan. And what you're comparing there is what everybody else is using.
Mm-hmm.
And in order to be registrable, what happens is the USPTO examines what you're trying to register against what is already registered. And if the sight, sound, or meaning are close enough, they don't have to be exact. If they're close enough, then you might get a rejection. But otherwise, if it's different enough, you'll get a registration and a trademark.
Yeah.
For copyrights, that's your creative content. That's your writing, your software, your art. And when you put all that together, that comes into fruition automatically. But registration helps with that.
Yeah.
And then, as I mentioned before, trade secrets are your proprietary business information, your formulas, your processes, your customer lists, things like that you want to protect from your competitors have.
Mm-hmm.
And as I mentioned before, most businesses need some combination of those four. And talking with an IP attorney on the front end helps out a lot with that.
Got it. Would it could something be more than one thing? I'm thinking of like a trade secret could also be a patented process, so to speak, right?
So that's a great question. No, because patents are public disclosures. And so
It's got to be,
what you're
you can
getting
go to
in
the
return,
U.S. Patent Office and look it up and analyze it.
exactly. So what you're getting in return for disclosing your invention is 20 years of exclusive use. I think of a patent as a piece of land with a fence around it, that the fence is slowly degrading over 20 years. Eventually, the fence goes away, and the land is now free for everyone to use. Trade secret, on the other hand, that is Fort Knox. Those walls aren't going anywhere so long as you don't let anyone in.
All right. No, and I've got some experience in this space and talking with, startup companies and such. And I'm wondering, as it comes up, people express like, oh, I can't say anything. Do founders need to worry about sharing an idea too early, with an investor or partner, or, even other companies that, they might thinking there'd be a compatible, joint venture or something?
Yeah, absolutely. It's, in my opinion, it's one of the more underappreciated early stage risks with new ventures. An NDA is always advised. Or alternatively, if it's something that's worth patent protection, filing a provisional patent application, as that allows 12 months of patent pending status.
Oh, okay.
For you to figure out, is this even worth it? One, to file a patent, utility patent, or to, work with investors and see if it's something worth their money. And then on the flip side of that, that disclosure that you're providing to these investors, there needs to be some sort of protection in place. So as I mentioned, the NDA is worth having. Now, enforceability of those NDAs does vary throughout the states. But it's a state by state, case by case basis, depending on how the NDA is written. But overall, it provides a good scarecrow effect to have an NDA in place.
Yeah, I do wonder about the NDA. Is state by state, you said, right? So,
Correct.
I mean, I've signed many of an NDA, and part of it is in my, I'm not telling anybody anyway, so whatever. I don't tend to read them too in much detail, but I do wonder, it's sort of like the non-competes. I was having a conversation with an attorney. Non-competes get a lot of questionable enforcement there lately, and the trend is definitely like he was very much emphasizing the importance of the NDA and in terms of enforceability.
Absolutely, yeah. Non-competes a little questionable these days. NDAs still pretty rock solid, and it's contract law, so it's very state dependent.
Yeah. Okay. No, I know. In your practice, you've worked with a ton of businesses, and I'm wondering, do you have a kind of case study, so to speak, that a client, or should have been a client, maybe waited too long to protect some sort of intellectual property, and then was kicking themselves for that?
Sure. I'll start in the trademark realm. I had a local pizza restaurant get a cease and desist letter after having been in business for, I want to say, about a year, from a pizza place up in Chicago that had a federal registration. And when you have a federal registration, that implies a nationwide protection. And so they get the cease and desist, and unfortunately, they never responded to it. And so litigation was started, and they were forced to defend themselves from that litigation. I think we ended up with a pretty favorable outcome out of that. But overall, had they done their due diligence on the front end, they wouldn't have had to go through that litigation. And, so from the trademark realm, that's definitely something that would have helped to do something on the front.
Was it a trademark situation?
It was a trademark. Yes, trademark. Sorry, go ahead.
Before you get into the patent thing, if the Florida client had never registered but had been using the pizza logo for longer than, or because it's possible, right? They'd be using it, and the Chicago business registered federally, and it didn't show up as a conflict because Florida hadn't done anything to register. Is there anything there where, like, hey, my client's been using this thing for 5 years? Is there or is that a state by state, or?
Well, so, right. So there's actually two regimes in terms of trademarks. There's the federal regime, and then state by state, there's common law protection, which covers geographic use. So let's say the pizza place had been using their name here in Tampa for 20 years. Yeah. And they get this letter, and they're allowed to go back and say, listen, we've been using it for 20 years here in Tampa. You guys just started a couple of years ago. We have exclusive rights to this area. You can have the rest of the country, but we have priority here. From a common law perspective, they would have protection there.
Got it. So a little bit of a compromise there. Yeah, but they couldn't then expand beyond. They couldn't take that name, national franchise situation, obviously. which is what the Chicago company was probably planning for.
Correct.
Yeah.
Right.
Yeah. And you were going to speak to the patent, not moving soon enough on the patent situation.
Sure. So from my perspective, the experience I've had with that is somebody who has a patent who didn't enforce it soon enough.
Oh.
And so when it comes to that litigation wise, you have 6 years worth of damages you can go back on, and your enforceability is for 20 years. So technically, you can go back 26 years.
Yeah,
On a patent.
That fence idea that you spoke to, right? Yeah.
Exactly.
Yeah.
And so we had a client who had a very old patent, I believe it was from the 90s, and they didn't realize that there was an infringer out there for a very long time. And I want to say we were 24 years out. So there were theoretically some damages to it, but overall, it wasn't worth it to move forward with the litigation. And so, my advice to them was, hey, we can send them a letter, get them to stop. They're not going to. But, at the end of the day, we need to do better policing.
Yeah. Well, I was wondering, as we were talking about that, it's like, how would I even know that somebody was infringing on my patent? Depending on the industry or the nature of it, right? It's like,
Sure.
like you said,
smaller industries, it's easier to police, obviously. But the larger, for example, like, textiles or,
right,
some chemicals, it is harder to police because one, a lot of those patents are methods, and methods are very hard to figure out if there's infringement because, manufacturers, those are closed doors.
Yeah, I'm not in your factory looking at how you're creating that textile to know.
Exactly. So my general advice to clients when it comes to method patents is, make sure that this is really, really the only way that you can make this thing, because if we find this thing out there, then we know the method has been infringed.
Yeah.
Otherwise,
like a particular weave or whatever it might be, a stitching technique or something. It's like.
Exactly.
Wow.
So at the end of the day, the cost associated with getting trademark or patent protection on the front end almost always dwarfs the cost of dealing with it later.
Oh, that's a great note to end on, honestly, because we're pretty much out of time here, Cole. But man, super interesting. Thanks for sharing your expertise and point of view on this. And I look forward to connecting in the future on additional episodes.
All right. Thanks, Sean. Have a great one.
You too. Thanks for listening to Mark My Words with Cole Carlson. If you're building something valuable and you want to make sure your ideas, brand, or intellectual property are properly protected, visit the website carlsoniplaw.com. And be sure to leave a review here, maybe a thumbs up, subscribe to the podcast. This is going to be a great ongoing series on intellectual property, and you're not going to want to miss any of it. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.